All right, welcome everyone. We're going to go ahead and get started. We have a full room tonight. Thank you all for coming for our first return to in-person Ask an Expert programs. This is the first one we've had here since 2020 when the pandemic stopped everything. And St. Paul's, then we continue to do the programs, but we just did videos and posted them online and on our Facebook page. So if you're interested in seeing any of the past ones, they are available on our website. But we've been doing these programs since 2017, really on a variety of topics of interest for older adults or for family members that are providing support for older adults. And we ask experts in from the community to join us to present on different topics and then to be available to answer questions. So that will be what we're going to be doing tonight as well. Just a few housekeeping things. If you need a restroom while you're here, there are two straight down this hallway on the right. So if you start walking down the hall, you'll see the big restroom signs sticking out in the hallway. So there are two of those. Please help yourself if you need a beverage or a cookie while this is going on. One thing to keep in mind, we do have folks that are joining us online on Zoom. And if you look over there, there's some speakers hanging on the wall, and those are very sensitive. So if you're whispering to the person next to you, it might pick that up on the Zoom. So just be a little conscious of that. And we'll try to keep that to the minimum if possible. In your seat when you came, we put a tablet there for you and a pen if you'd like to take notes. And our speakers tonight also had some handouts for you. And the last thing is a survey. We would like to ask you before the end of the evening to fill that survey out. And we will be using that to draw a couple door prizes at the end of the evening. And you know what? I don't even think I introduced myself. So let's back up. My name is Dawn Hartman, and I am the Director of Strategic Giving here at St. Paul's. So I work in our charitable giving office. Estate planning is something that I help folks with when it comes to charitable giving. So kind of our topic that we picked for this first Ask an Expert. All right, and in the hallway when you came in, you would have met two of our other staff members from the charitable giving department. Teresa Finley, that's in the back, walking up towards me. She's our director of annual giving. And then in the hallway is Vicki Hildebrand. She is our administrative assistant and also a receptionist, helps with different things at the colony here. So that's who we are. And now I would like to introduce our president and CEO, Chris Wright, for St. Paul's. He's going to share a few things with you before we get started. Thank you again.
Thank you, Dawn. Good evening, everyone.
Good evening.
It's great to be with you all in person. It seems like it's been forever since we've had the opportunity to get together, and I'm certainly grateful that we can do this again. And I hope that you find tremendous value in tonight's opportunity to ask an expert all the things that you've been thinking about at home for the last couple of years while we've been pent up with the pandemic. So I see a lot of familiar faces in the room, and I also see some new faces. For those of you that might not be that familiar with St. Paul's as an organization, I'd just like to give a quick overview of St. Paul's. We're 155 years young at this point. We were founded as an orphanage, and we've grown into a senior living community that you see today. So we offer services from home and community-based services to independent living, personal care, skilled nursing, and we also have a variety of joint ventures that are all tailored towards the senior living industry. This organization has grown tremendously, obviously, since it was an orphanage, but even in recent years as well. Actually, throughout the pandemic, our independent living community experienced a tremendous amount of growth, and we're thankful for that. We're thankful for our beautiful campus and the fact that we're almost done at this point with developing. So that's just again, a real high level overview of St. Paul's. Love to address any individual questions that you may have, and any of us are willing to do that. I did want to spend just a couple minutes talking in general about healthcare, predominantly healthcare post-pandemic, because I think that there's a couple things that might be helpful for all of us to kind of keep in mind in the event that we need services in our community. You know, the pandemic has changed a lot for many of us, and our industry has been and continues to be significantly impacted by the impacts of the pandemic. Many of them were going to occur regardless. It's just that the pandemic kind of sped them up. One of the things that we all experience, not just here at St. Paul's, but at the hospitals, at doctors' offices, and other businesses, are staffing shortages. And there are a lot of reasons for staffing shortages, but one of them that is often overlooked is the fact that we have the largest working generation in this country's history is now reached retirement age, or has been reaching retirement age. And we had built an economy that was really made to support them. So now we're kind of in this weird spot where, you know, we've got more jobs than we have people that are wanting to work. And we're all trying to manage that. We're all trying to deal with that. Hospitals in particularly have many of their beds that are offline right now, mostly because they can't staff them. It's not because the volumes aren't there. You know, we as an organization are continuing to try to hire. We have skilled nursing beds that are also offline. We're trying to take as many skilled admissions as we possibly can to serve our community, to help folks that have a short-term rehabilitation need recover and get back into their homes. And because of that, you know, we're in a little bit of a transition phase, or a bubble, if you will, in that we're unable to take long-term admissions into skilled nursing. So if you hear in the community that you can't get into St. Paul's, and you know someone that's trying to get into the villas on a long-term basis, it is possible that that's the case, because we're trying to keep our short-term beds open for those folks that need that rehabilitation stay. We are hoping sometime this year to be able to change that. But that's kind of the bubble that we're living in right now, and that's a little bit of a background as to why. One of the things that I would encourage each and every one of you, in the event that you do need services that relate to healthcare, make sure you yourself are an advocate for yourself. And if you can't be an advocate for yourself, make sure you get an advocate. You know, no one can speak for ourselves better than ourselves, right? Or a loved one that supports us. And the healthcare system is very, very busy right now. And they're trying their best to provide service, but much like us, they have a lot of people that need to come into their facilities as well. So if they're asking you to do something, or if they're asking you to go home and you personally don't feel like you're ready, or you personally don't feel like you may be getting the services that you need or deserve in their system, make sure you speak up. Make sure you advocate for yourself. Make sure that you talk to those nurses, and you talk to the discharge planners, and you talk to the social workers, and advocate for the services that you deserve. Because there are times and there are instances where if you don't, they may make the assumption that, you know, you're good to go and that you're well enough to be able to get discharged out of a hospital. And then a couple days later, you end up back in there. So again, we're just kind of in a unique time with staffing shortages and changes as a result of the pandemic. And that's probably the best advice that I can give someone, is to use the voice that you were given and demand that you get the services that you need, because you will be and you are your best advocate. So again, I'm glad to be with all of you this evening. I'm glad you came out. It's a beautiful day. I don't know who ordered it, but I'm grateful for it. It's certainly changed from what we've been experiencing. And I hope you enjoy our presenters, and I'd like to thank them for taking time out of their busy schedules as well to come here and be with us this evening. So thank you.
Chris. All right, so our topic tonight is Estate Planning 101, and we're very fortunate to have some wonderful resources here in our community that we have worked with at different times at St. Paul's that have agreed to join us this evening. We have Carolyn Hartle. Carolyn is an attorney. Hartle Elder Law Practice, which is in Hermitage, and her specialty really is elder law and estate planning, estate administration, and special needs planning. So she has a lot of knowledge to share with you this evening. And our other presenter is Kevin Orsinger with Orsinger Investment Group here in Greenville, who is going to talk a lot about all the financial aspects of estate planning and how you get ready for that. So I'm very pleased to have both of them here with us. Kind of the format this evening, we're going to have each of them present. They have some materials that they would like to present, and then we'll open it up for questions. So if you have a question, if you jot that down for a little later, because we do have a lot of folks in the room tonight. I want to make sure they get through all they'd like to share, and then we'll do questions. For the folks that are online on Zoom, if you have a question at any time and you want to put it in the chat box, which you can see at the bottom of your screen, if you hover on there, there's a chat option, and then we'll check those at the end when we're going through the questions. All right, well, thank you very much. And I believe Kevin is going to go first.
Thank you very much. I've been fortunate enough to do this with Carolyn a couple times over, I'd like to say 5 or 6 years, but if I'm being honest, probably longer than that. COVID for me, it either happened yesterday or 10 years ago. I've got virtually no memory in the middle there of how long things last. I will also say this, if you could call me an expert more often, it is really good for my ego. So I appreciate that, and feel free to just blast it out anytime you want. So I have some things prepared that I want to mention, just kind of big picture, broad picture wise. And like I said, I'm more interested in what questions you guys have and maybe what in a little bit more detail that we can answer for you. But we start with all of our clients as they come in. If we're going to talk estate planning, and that can be leaving anything behind to anybody that you love. It starts with a plan. Those that know me well know that I'm a control freak when it comes to my life, and I don't want anyone making any decisions for me. I kind of have that same approach with my clients. If they're willing, let's lay this out exactly like you want it laid out to make sure that your hard-earned assets are going to the people or charities or whatever that you would like them to. Like I said, it all starts with a plan. Understand too that over time, the plan is going to have to be fluid and flexible. It's not as though you can put a plan in place today and think that 15 or 20 years from now, it's going to look exactly the same. Situations are going to change. Potentially people are going to change. And being able to go back and review that plan and update that plan on an ongoing basis is an important part of any sort of planning process. The planning for us starts with, who do you want to bless with this gift? And again, is it going to be sons and daughters, nieces and nephews, grandchildren? We have some clients that have said, listen, we've done enough for them over the years. They're in a good position financially. We would like to help other organizations with our money. So again, you have many, many options and many, many different places you can leave your hard-earned assets. One of the things too that I haven't talked with clients with, but I've been thinking about doing it too, as part of this planning is, and this may sound a little bit weird, is to write your own obituary. You know, I think about, my mother passed away here in 2015. So yes, so it's nearly 8 years here at the beginning of next month. We had to sit down as a family and write it. And it was, you know, it was cathartic on some levels and healing on some levels, but also very difficult. So I think there's a great bit of value in sitting down as part of your estate plan and writing your own obituary. What things would you like people to remember about you as they're going to celebrate your life at some point in time? So again, the first step is just you need to have some sort of plan in place. You need to understand that plan is going to be fluid and you're going to need to make adjustments to it. And again, you have to pay attention to that plan as years pass because situations are going to change. I'll just touch briefly on it. The next thing we talk about with clients is to find a good estate planning or elder care attorney that can help you with all the legal documents. Wills, power of attorney, advanced healthcare directive. There's probably 100 more that I don't know about or don't know how to use properly, and Carolyn will touch more on that. But as part of your planning, it takes a team of people to help you with that. You know, our part is maybe how to divvy up money. Her part is to make sure that it's going to the right people in the right manner. If you have investment accounts, life insurance policies, even some bank accounts in some situations or circumstances, you want to make sure you have beneficiaries listed on all of those accounts. The first reason to do that is obviously to make sure the money goes to who you want it to go to. The second part of that is any of those accounts or policies that you have a beneficiary listed on, that money bypasses your will and bypasses probate and passes directly to your beneficiaries without any additional costs or charges. So again, as part of the reviewing your plan, this is something we have clients do on an annual basis, is do we still have the beneficiaries correct? So again, in a lot of cases, it's your spouse will be your primary beneficiary and children could be your contingent or grandchildren could be your contingent. But again, as situations change, as life changes, maybe that needs to be addressed. We've had more and more clients over the last couple of years not leave 100% of their assets to family as they've gotten older, that they've realized they wanted to do something a little bit bigger and a little bit grander and leaving money to charitable organizations. Even non-IRA investment accounts, which are sometimes referred to as brokerage accounts, you can title those as transfer on death, which just gives you the opportunity to add beneficiaries to it, which again gives you the opportunity to have money passed directly from that account with basically a couple of signatures from the beneficiary and a death certificate, and the money transfers very, very quickly. You can also do payable on death for bank accounts. We don't recommend that always because you want to leave some money in the estate to cover any costs. But if you have large sums of money at the bank, sometimes it's smart to do that. Again, we want to make sure we can bypass your will with as much money or assets that we can in order to reduce the cost of your estate. All righty, here's where we'll talk big picture, and if anyone has specific questions, we can answer them later. Depending on the type of account that you have, whether it's an investment account that might be an IRA or a life insurance account, you may want to make different beneficiaries for those different accounts. So the benefit of life insurance policies, those death benefits pass 100% tax-free to the beneficiary. So if you were going to split your estate between family and charities, we usually recommend to clients that money in life insurance policies goes to your families because they don't have to pay any sort of taxes as they inherit that one. IRA accounts are different. They are not taxed when they are received, but there is taxable income that's generated from those accounts that the beneficiaries will pay over the years. So again, if you're going to split your estate between family and a charitable organization, we usually recommend that some or all of the IRA get left to the charitable organization because they have no taxable event upon selling and receiving those dollars. So again, it's big picture stuff, but we're not a blanket recommendation kind of firm or a case by case have discussions to make sure, but just something to consider if you're looking to split your estate between individuals and charities. It's really going to come down to what accounts should go to what groups or organizations. Okay, how many people here are big fans of our friends in Washington, D.C.? Big fans of Congress here? Good, okay, fantastic. So In December of 2019, Congress enacted something called the Secure Act, which changed the IRA beneficiary rules significantly. So the old rules used to state if you inherited an IRA, spouse to spouse, your spouse could just absorb that IRA into theirs and nothing changes. That money becomes their money, and life moves on. The new rules for IRA distributions for spouses have not changed. So if your spouse is your primary beneficiary on an IRA account and you leave them as the beneficiary, they can just either absorb that into their IRA or just change the name on the account to make it theirs. If you're leaving money to children, grandchildren, the experts, if we're lucky enough, the rules have changed. The old rules used to state that if I inherited an IRA from my father, that I had to make annual required minimum distributions from that account based on my age. We refer to them as stretch IRAs because I could usually get higher rate of return in that account than what my minimum distribution was. And if I was lucky enough to have that account for 20 or 25 years, I probably have significantly more money at the back end of that than what I started with. I think in part because of all the forced spending maybe that happens in Washington, the IRS and Congress have realized that we need to get our money out of those IRA accounts sooner. So the new rules for beneficiary IRAs for non-spouses state that, again, same scenario. I inherit an IRA from my father. I still need to make an annual required minimum distribution in years 1 through 9. By the end of year 10, I have to have every single dollar out of that IRA. So at the end of year 10, if I was lucky enough to inherit a $100,000 IRA from a non-spouse, by the end of year 10, that account balance has to be zero. And the reason is that's $100,000 of taxable income that the IRS is going to collect their pound of flesh on. So it's frustrating that it happens. It's frustrating that the rules were written so poorly that it took most of 2020 for anyone to understand it. It's frustrating that they voted on this and approved this, I think, December 19th, and it went in place on January 1st of 2020, so there was no room to do any planning. But it is a game changer for estate planning, because now you're no longer able to leave a lifetime legacy to somebody, because they are going to probably over the course of that decade lose 20% of that account balance paid to taxes.
So you're saying that applies to non-spouses, kids, grandkids, nieces, nephews, but that does not affect the spouse.
Does not affect the spouse, so that is correct. So yeah, you can leave your money to your spouse and they don't have to take any withdrawals out until they hit the age of requirement. Yeah. And again, that's big picture. We can talk about that more if anyone has any specific questions on that. There are 5 eligible classes that don't fall into those new rules: spouses, adult children, and up until age 21. So God forbid someone passes away at 40 and leaves their IRA to a son or daughter who's 8 years old. They don't have to worry about making any distributions until age 21. Chronically ill, someone who's disabled, but there are very strict rules on what the IRS considers disabled for this. And then if the beneficiary is a non-spouse who is 10 years or less younger, 10 years or less younger than the account owner. So I'm 53, so if I passed away and left it to my neighbor who was 52, he wouldn't have to make required minimum distributions and take all the money out in 10 years. But it's an unusual circumstance, which is why I think it is in there. Anyone want to guess what my favorite solution for estate planning is? How are we going to get money from me to somebody else? I guess? No? Okay. So for me, it's gifting. So why wait? Why wait till I pass away to start to pass my money on to the next generation? Not in gobs, not half of my estate or something like that, but some sort of planned out annual gift. Again, children, grandchildren, your favorite charities, whatever it is, let's start to get some money out of our estate sooner rather than later. I'm a control freak, as I may have mentioned earlier. I'm also apparently an expert. Okay? Again, I'd like to hear. You know, as a control freak, I would like to give my money to either individuals or charitable organizations and see the good they're going to do with it. Like, I think there's value in that. I'd like to be able to, as I get older, make some donations and see some nice things happen so I can actually witness it and see the benefit and joy that maybe that money has provided. Any individual is permitted to gift to another individual up to $17,000 a year. So that's a sizable amount of money without either party having to do anything else.
That's just in Pennsylvania, is that?
It's federal. Yep. So it's across the country. In our lifetime, and we should all be lucky enough to have this problem, any individual is permitted to gift $12.92 million to other individuals without any sort of issues. Again.
The person receiving the gift money, is that like to be put on income taxes then?
No,
No tax whatsoever?
I could write you a check for $17,000 right now and
Okay.
you wouldn't have. No, that's how it's try. Hypothetically, I could write you a check for $17,000 today. I would not have to show it on an income tax return and you would not have to claim it on an income tax return. If I was feeling extra charitable hypothetically, and I wanted to write you a $20,000 check this year, you could still accept that $20,000 check and do nothing with it. When I file my tax return, there is a form, it's IRS form 709, that I just have to disclose that I made a gift of $3,000 higher than what I'm permitted to. And the reason for that is the IRS uses that to calculate, am I getting close to my $12.92 million lifetime gift exemption? Again, I'm a big fan of that, whether it is family, friends, charities. I am a big fan of let's do some gifting sooner rather than later.
That's 17,000 per parent to a,
Per person, per individual.
so we could do 34 then.
Yes, you could do 34 to each child. You could also do 34 to each grandchild. You could do 34 to your neighbor. Yep. So yeah, that $17,000 is one individual's gift to another individual. I've got two more things and I will be brief because I know Carolyn's jumping in the bit to get started. One of the ways that you can make gifts, and I'll just use St. Paul's as an example, is anyone here old enough to have to take a required minimum distribution out of their IRA? 2 or 3 of you? 4. Okay, so 4 of you. So, you know, the money has to come out of your IRA. The new age is 73. So if you haven't started it and you're 73 this year, you're going to have to start taking required minimum distributions from your IRA. IRA money, which in most cases was 401k or 403b money previously, has never been taxed. Not a dime of taxes has been paid on that money as it's grown year over year over year over year. So the IRS's required minimum distribution rules are forced distributions because, again, it's taxable income and they would like their pound of flesh from it. So we have many clients that take the required minimum distribution, pay the taxes on it, and then don't need the money. So the solution for that, if they are charitably driven, is you can do what is called a qualified charitable distribution, which means you can take money from your IRA up to $100,000 annually and give it to one or many charities. You don't pay taxes on it. So if I decided, listen, St. Paul's, I'd like to make a $25,000 gift to you. It makes no sense for me to take it out of my IRA, pay taxes, and have to find other monies to put with it to get the $25,000. I am just going to make a gift directly from my IRA account to St. Paul's. the best part of this, you don't pay any taxes on that distribution, but it also satisfies, potentially at least, satisfies your required minimum distribution amount. So you're able to make a gift to your favorite charity, 501c3 charity. So it has to be a registered charity. It can't be your neighbor kid's lemonade stand who's trying to raise money for something. It has to be a legitimate charity. But instead of taking the money out and paying taxes, giving some to Uncle Sam and giving what's left to your favorite charity, you can give all of it to your favorite charity. Like I said, up to $100,000 a year, which is a lot. I understand that. We have not had any clients that have been that charitable over the years, but we have had some that have taken advantage of it. Yes.
Don, when you were talking earlier about if you, children inherit the IRAs, they have to empty it out to zero balance in 10 years. Can they do charitable?
Only if the child who inherits that account is age 70 and a half or older. So yeah, so if you're 45 or 50, that is not an option for you. The rule, we'll call it, for lack of a better term, starts at age 70 and a half, or what used to be the old required minimum distribution age. And then I will finish with one thing. I know Don has some booklets up here, but inside the Orsinger Investment Group folder, on the left-hand side, it's something that I think is an important part of the planning, and that's really, how am I going to organize my financial life? That if God forbid something happens to me and someone has to come in and close up my estate, how do they know where my investment accounts are? How do they know where my life insurance policies? You know, where's the titles to the car? Where's the deed to the house? All of that stuff. It's homework. It's not something you're going to sit down and knock out in a half hour. But there's value to it, to the people that are going to help sell your estate, including, and I hadn't given any thought to this, I'm actually in the process of updating mine because I haven't done it in a couple of years. How important logins and usernames are. I don't think about it daily, and you guys are probably the same. How many bills I pay online and how many statements I don't even get in the mail anymore because it's available online to me, and the 900 accounts and logons and passwords that I have that I can't remember what they are without looking them up, that they need to be made available to somebody in the future. So like I said, that is an important document that I think goes with the whole, let's make a plan today, and knowing that that plan is going to be fluid and flexible. And honestly, you're making the person who's got to sell your estate, you're making their life a lot easier. And I would guess most of you probably want to do that for children or grandchildren or friends or whoever is in charge. So that's all I have. I hope I didn't go over my minutes.
Good, good.
Thank you.
Everyone, can you hear me okay? No? How about now? How's that? That better? Okay. Tonight I'm going to speak simply on estate planning, and there are 3 important documents everybody should have as part of their estate plan: power of attorney for finances, an advance directive for health care, and a will or a trust, depending on your situation. Now, critical thing is you can't wait too long. In order to execute any of these documents, you have to be of sound mind and understand what you're doing. If you wait too long, it's too late. And then you're not going to have the choice of who's going to act on your behalf. That's the importance of doing this. You're getting to choose who's taking care of your finances, who's going to make your medical decisions for you if you can't, and then who's going to take care of your affairs when you die. So you're taking control of your situation, plus it's a gift. You're not leaving a mess behind for your family and loved ones if you become disabled or pass away. So this is why you do it. So the power of attorney for finances is a document that says when and if you are no longer able to take care of your own affairs, whether you're physically or mentally incapacitated, you're naming somebody to do it for you. The idea is for it to be used when you cannot take care of your own affairs, but most of the documents, the power of attorney, are drafted that they can be used right away for convenience. Unless you have language in the document that says nobody can use this financial power of attorney until 2 doctors put in writing that you're incapacitated, can't handle your finances. So that is the right language to have in some of the power of attorneys. But if you trust the people you're naming, it's a hassle for them to even start paying your bills because they can't do anything until 2 doctors put in writing you can't handle your finances. And think about how long that could take. So it's right in the right situation where people know they need a power of attorney but don't have good candidates, then that language is critical. But if it's a child that you trust and it's good with money, it's not necessarily needed. Plus, there are other ways you can protect yourself so the power of attorney doesn't get used prematurely. So you want to name somebody who is good with money and you trust. So I always say, just because your son is the oldest, doesn't mean he's the one that has to act. Especially if he's filed for bankruptcy 3 times already, he is not the guy for the job. You need somebody who can take care of your affairs. It doesn't have to be anybody local because bills can be paid online, bills can be mailed. So financial power of attorney is not necessary that the person's local. You can name 1 or more people as your agent if it's going to work. So you can name 2 children, but it only makes sense if they get along. They could never ever decide agree on what color the sky was. You never want them to act together. Nothing's going to get done. But if you have people who get along and are like-minded, then it could work. And then you have to decide, how are they going to act? Do they have to do everything jointly? So that means both people have to sign a check, or can one act without the other? Because the language in the power of attorney will control how that works. And if you trust the people equally, then it's more convenient to say that they can, Johnny or Susie can act, which means they can act jointly or individually. Right, so you can name 2 people. We always want you to name at least an agent under power of attorney, that's what they call them, and a successor agent. Because as long as you're of sound mind, you're taking care of these affairs, name your primary person and then your backup. Because if your first person passes away, and now you cognitively no longer have the ability to do a document, and you didn't name a successor, you've got a problem. So you want to name a successor so that you stay in control if down the road you are no longer able to change your document and your first person passed away or they're incapacitated. Because if you don't name a backup and you are no longer of sound mind to execute a new power of attorney, then somebody's going to have to petition the court to become guardian. And it could not necessarily be who you want. And if you don't do any planning and your family has to become a guardian, you thought paperwork was bad. Having to file the guardianship reports every year for finances and medical decisions have now become a very tough process because it's all computer driven, it's complicated, and they have the computer software has like different flags. So if you made a gift, you're getting a call from the judge's clerk wanting to know about the gift because you have to get court permission to make gifts. So even if it was a $25 gift card to Giant Eagle, you're going to get a call from that law clerk wanting to know why didn't you get court permission? So you're making life easier for the family as well with the power of attorney. One, yes, they still have to keep records and accounting, but it's not as difficult a process as the court guardianship. So that's one of the things. So if you want to be very specific in your power of attorney and look at it to see, does the language in the power of attorney cover all the assets that you have? So if you have a life insurance policy, but your power of attorney doesn't mention that your agent can take care of a life insurance policy, that's not very helpful because your agent can't do anything. Companies are very, very picky, correct? If they don't want to part with the money that they're holding for you, they're going to look at the power of attorney to make sure that, if there's any reason why you don't have access to it. You have to be very careful. So if you have annuities, make sure you have language in the power of attorney that allows you to deal with annuities. Then there are specific, what they call hot powers, that you have to specify if you want them or don't want them. One involves gifting. If Pennsylvania power of attorney is very specific on gifting authority. If you simply say your agent can make gifts, then it's presumed to be limited gifting. which means they can only make gifts of the, what they call the annual exclusion, which is currently the 17,000 per year, only to the children of their spouses and their own spouses. So it doesn't get you very far. If you want to be able to make big gifts, whether it's, your RMD that might be a $20,000 RMD, you need your power of attorney to say unlimited gifting. If it doesn't say unlimited gifting, you can only do the 17,000 per person per year. If it doesn't mention gifts at all, you can't, your agent under power of attorney cannot make any gifts. If they do, they breach their duty. So you have to look at the document. If you want to be able to protect some assets down the road, no offense, from a nursing home, you need to stay out of gifting. If you don't want gifting done, and maybe you just want some strategic, 17,000 per person for your gifting for estate planning, but you don't want to open it up very broadly for them to make gifts, then you want it to say limited gifting. So we always ask the client the question, if you want to protect assets in the nursing home, then we have to have this set of language. If you don't, and that's not your concern, then we're not going to put it in the document, because we don't want your agent down the road who they may want to protect assets to have the language in there and do it, because for us, the client's the one that we represent and we take care of. So if we know the client doesn't want to do nursing home planning down the road, we're not putting the language in the document that would allow the agent to do it, because it wouldn't be their wishes. So we always ask that question, and we put specific language in it depending on what your goals are. So we don't just do cookie cutter power of attorneys. We ask specific questions, and then that dictates what we put in it. For example, changing a beneficiary. You have to be specific in a power of attorney whether or not you're allowing somebody to change beneficiaries on life insurance or IRA. And again, because if a company gets a change of beneficiary form from an agent under power of attorney, they're going to have their legal department look at the power of attorney to see, does this person have the authority to do it? And if not, they're not going to process that. You really need to look at your power of attorney and make sure it has everything that you need it to. Right? Because it is problematic. We, had a couple cases where the people needed to cash in the life insurance, and the power of attorney document that was drafted for them doesn't have any language on it. We couldn't even get information on what the value were of the policy was. We left out, and the company told us, although they shouldn't have, but at least we had a figure. We didn't have a figure before. All right. Now the power of attorney ceases upon death. Then the other important, but it is one of the most important documents you're going to have, because you're giving that person a lot of authority. So you need to think long and hard about, is it the right person? And what do you think you should do if you're thinking about naming somebody? You need to ask them, are you willing to do it? Because being an agent under power of attorney is a job, and you could be doing it for several years. So make sure your person's willing to do it, because if you name the person, the day comes you need them to use the document and they say, I'm not willing to do that, then you really haven't accomplished too much. You hopefully named a successor who's willing to do it, but if not, you've got a problem. Right. So then the advanced directive for healthcare is the next document that you would need, and that's obviously all regarding healthcare. And it's much different than the financial power of attorney, because it does not get used or triggered until the doctor says you are no longer of sound mind to make your medical decisions. So as long as you're of sound mind, you are the only one who can make your medical decisions. And then this document is broken into two sections: a healthcare power of attorney for the everyday routine medical decision making, and then living will for end of life. So you want to name an agent for this. And your agent's job is this: to step into your shoes and make the decision based on what you want, not what they want for you, and not what they would want for themselves. So you need to think long and hard about who's going to be able to do that, because they're doing it at a crisis time. Usually it's end of life. So if you have a child who's too emotional and isn't going to be able to fulfill the wishes that you want, don't name them. If they're not going to be able to do the job, don't even put them in that position, and your wishes may not get followed. I know I'm not going to be named on too many medical power of attorneys, because I get lightheaded and queasy at the doctor's office, so I won't be listening to them. So you would never, ever name me. My poor husband, he's got problems, but yeah, you got to think long and hard if you can do the job. So if you have somebody with a medical background, that's helpful. They're gonna know the reality of what the situation is. Somebody local is a little more helpful because if you need rush to the emergency room and somebody needs to give consent for surgery, it's helpful that there's somebody local. Doesn't have to be, but it is sometimes helpful. I mean, now with technology, I mean, I'm an agent under power of attorney for a little lady, and they texted me if I consented to surgery, so I just texted back, yes, I didn't even have to go in and sign it. Granted, that was during COVID, but it was kind of convenient for me. So if you had a child who was long distance, that would be helpful as well. That document ceases upon your death as well. But as long as they're sound mind, you can always change your document. And you can name two people on that as well, but as long as they're going to get along. Now, sometimes some people think, well, I don't really have anybody, and they're concerned about the person following their wishes. Well, the form we use has a question that asks, how much authority are you really going to give your agent? And there are two choices. The first choice says my agent must follow these instructions. So if you mark that one, that means there's no flexibility, there's no deviation. If you mark no feeding tube, no extraordinary, measure should be taken, there's nothing for them to think about. You look at the document and that's it. So if you have that emotional child and you mark it that way, there's not as much for them to, they really have nothing to think about. But it's still not really a big choice. The other option is, it says that my agent can follow these instructions as a guide, but they have final say and can override my decision. So that one does give them flexibility making those end of life decisions. So you have to think about, do you want your agent under power of attorney to have flexibility or no flexibility making those end of life decisions? And then you fill out the form accordingly. Now we do an advanced directive for healthcare, which is part 1, healthcare power of attorney, part 2, living will. Some attorneys will break them up into 2 separate documents. But the critical thing is a healthcare power of attorney is dealing with your everyday routine medical decision making, not end of life. That's the living will. So any of you who've gone to the doctors and they have, you do have a living will, if not fill one out, look at it. It's just going to cover end of life decision making. It's not going to cover those everyday routine decisions, which are critical because if people get older, their cognitive functioning, fails. We need somebody to give consent to gallbladder surgery. That's when the healthcare power of attorney would come into play. The your living will is not going to be very helpful. So you need them both. Healthcare power of attorney for the everyday routine medical decisions, living will for end of life. Okay. And then again, that ceases upon death. And then that's when your will comes into play or a trust. So on one of the handouts that I gave you, and Kevin touched upon it, is trying to avoid probate. So a lot of people, they say they want to avoid probate, they have no clue what probate is. They just know they're told they need to avoid it. So probate is the process of going through the courts when you have a will to take care of your affairs when you pass away. So probate assets are only going to control, that your will controls probate assets. And a probate asset would be something like a house, bank account, car, investment account in your name alone without a beneficiary on it. Now your will is going to control who inherits that and how, and who's in charge of it when you die. Non-probate assets are assets that because of how they're titled or what they are, we're never going to look at your will. So having a will does not equal having beneficiaries on your IRA, life insurance policies. You've got to do that with a company that's holding your money. So non-probate assets would be bank accounts that are held jointly with people, whether they're spouses or a parent and a child. And that could be a house. It has to be worded a specific way if you're not husband or wife, but bank accounts, investment accounts, those all avoid probate because if one person dies, it automatically goes to the survivor. If you had an investment account, Kevin said, and you named a beneficiary, that's transfer on death. We're never going to look at your will. They're only going to look at the person on the beneficiary form. Same thing with a bank. You can have a beneficiary in a bank account, whether it's a CD, savings account, checking. If you have IRAs, annuities, life insurance policies, you need to name beneficiaries because that's what they're set up for, to avoid probate, but only if you name a beneficiary. If you, and then make sure you name a contingent beneficiary, because if your first beneficiary passes away and you never go, complete a new beneficiary form, your estate becomes a beneficiary by default. So if you have $500,000 IRA and you named your spouse and you never got around to naming contingent and your spouse died, you just created a tax nightmare for your family, because that now, instead of being able to pull it out over a 10-year period of time, when it goes to an estate, it has to come out in 5. So that would hurt a lot more. So it's critical to name a beneficiary. Okay. So also, if you had a trust avoids probate because the trust is the owner of the asset. So you don't go through probate on that because your trust owns it. So if you had a house, the trust owns the house. So you avoid probate because you've already transferred ownership. Now, a trust, there's 2 types of trust: a revocable trust, which is good for estate planning, and then an irrevocable trust, which you do more so for if you have the problem of having more than 12.92 million, then you need a specific kind of irrevocable trust to try to protect assets for federal state taxes. And then there is an irrevocable one for nursing homes. But a lot of people do it for estate planning now, and that's because you can avoid probate. What's the real benefit if you don't really have a large estate? There are benefits to a revocable trust. One would be if the law firm who's handling your affairs when you pass away follows what's called the Johnson estate case, and it's the only court case in Pennsylvania that says this is what the court thinks is fair and reasonable for executors to charge to handle the estate and attorneys to charge. Johnson estate case says if you have assets in a trust, the attorney can't charge as much to handle your estate. I'll give you an example. If you had a will and you had $200,000 in assets, probate assets, under Johnson, the attorney fee is roughly $9,700. If the same $200,000 is in a trust, the attorney fees can only be half of that. We still have to do all the same work, still have all the same steps, but you save on attorney fees in the back end. Okay. A lot of times you would do trust if you don't want your beneficiaries to get access to the money right away. Maybe they're spendthrift. Maybe you don't like the spouse and you're hoping to get divorced, so you're delaying the distribution until the divorce comes through. We actually have had people who won't distribute any money to the child, but if they happen to get divorced, now it's like a flood. All the money can go out. If you have a child who's disabled and getting SSI or Medicaid, then you need a trust, because it's called a special needs trust that says that beneficiary can still keep getting their SSI check, they can keep getting their Medicaid check, and they can receive the benefit of money. But it has to be set up in a specific way, in a special needs trust, which says they can have access, they can have money from the trust, but it can only be used for things beyond food and shelter, because that's what the SSI check is supposed to cover. So, yeah.
So would that be set like in some type of an annuity where you only get so much every so often?
If the trust is set up that way. The way I kind of explain the trust, especially a revocable trust, is this. You know what a power of attorney is now, right? If you're incapacitated, somebody's going to take care of your affairs and pay your bills, and you know what a will is. Somebody passes away, who inherits a house. So for assets that are in a trust, and remember, you have to put the assets into the trust. It's not enough to sign a trust, and you need to fund it, meaning put the assets in the trust. So again, if you had a house, the house would be titled in the name of your trust. If you had a bank account, it needs to be titled in the name of the trust. Just think of it as a big container. If you have a trust, you need to get those assets into the trust, and then your trustee controls. So when all the assets are in the trust that can be in the trust, it's like a power of attorney, because if you're incapacitated, your trustee is going to take care of your money that's in the trust. And then it's like a will. When you pass away, the assets are going to be distributed just like, to a person in a will. All right.
So if my spouse, who I want to join on call my financial accounts, okay, if we decide to put our finances into that trust, then I drop dead. Does she have to go through the trust to get that, or does she still automatically, she's
So if it's a husband or wife setting up a trust, you guys be your own trustees. And the trust says you can use it on your money any way you want, just like you would if it wasn't in a trust. If one of you passes away, it stays in the trust for the benefit of the surviving spouse. to do whatever they want to it. You can still set it up the same way. It's just titled differently and you sign differently for it. Like when the house is in a trust, the only thing that changes is the title. Your keys are still going to work the same. You can still do whatever you want. It's just titled differently and avoids probate. But in a trust, you can, I kind of explain it as, think of it as a recipe book. Your trustee can only do what the trust says. So they can't make up their own rules. They can only do what the trust says. If they don't do what it says and make up their own rules, they've breached their duties and they can be held accountable by the court. And
If we're own trustees, then.
you still have to follow the rules of the trust. So for example, sometimes we have second marriages and the husband's holding most of the money. They didn't do a prenup, so the spouse does a trust that says, yes, my wife has access to the income and maybe a stipend every so often, but she's never, ever going to have full access because the person's concerned. She remarries. If she has full access to all that money, she can leave everything to the new spouse and not the children. So it all depends on what the trust says. And there's a lot of different reasons people set up trusts. But I wanted you to know the differences between probate and non-probate assets. Now, there's a lot of people, I believe, think that avoiding probate equals avoiding inheritance tax. That's false. There's no way around inheritance tax unless it goes from spouse to spouse to charities, or you have everything in life insurance. And it's triggered by you being a Pennsylvania resident and passing away. So it's triggered by the tax on the Pennsylvania residents when they pass away. And if the beneficiary's right to inherit, it's not free. And there's a spouses again are 0. Lineal decedents is 4.5%. Siblings is 12, and then everybody else is 15. Okay. And that means annuity, if you have an annuity, inheritance tax, IRA, inheritance tax. If you have just a car, it's subject to inheritance tax.
Can you repeat that, please?
The percentages. So lineal decedents, so like children and grandchildren, 4.5%. Siblings, 12. And then anyone and everyone else, 15. Whether it's a friend, a nephew, a cousin, they're all 15%. Charity, 0. And spouse, 0.
I'm sorry, is there a minimum number if someone's only has a car that's worth $10,000?
Still subject to
Still
inheritance tax.
subject, okay.
But, let's say the car is sold and the money was used to pay the funeral, it's gonna end up probably being 0 inheritance tax due because, it's a wash. But here's a kicker. Are you ready? We hear this all the time and actually it's frustrating. So people will put a child's name on a bank account with them because the bank told them to, because in case somebody goes to the hospital, they want the child to be able to pay the bills. And my next question always is, would you have a power of attorney? Well, of course I do. But then you don't need to put the child's name on the bank account because anything you can do, that person who's agent under power of attorney can do. Because here's what happens. When you put a child's name on your bank account and they die before you, you get to pay inheritance tax on their portion of your account. So if you had a $100,000 CD with a child's name on it and your child passed away first, you get to pay inheritance tax on $50,000 of your own money. Kept it in your name, then they can still access it to pay your bills with the power of attorney. Upon your death, they're going to have access to it because you open up an estate. There may be a week or two in between that you don't have access, but you will have access. And I think it's best to keep it in your name alone. If you want to name beneficiaries on it, great, you can do that. Because if somebody's acting as your agent under power of attorney, they still have duties and responsibilities. And if they make a misstep, they have breached their duties and be held accountable. A child is half owner of your account. They can take every single penny out of that account and you have no legal recourse. Now, of course, Johnny's never going to do that. Well, maybe Johnny's not, but it's that pesky daughter-in-law that you never liked is the one that's always saying, take the money out. So you got to be careful about that. Okay.
Transfer on death on the.
That's what I'm saying. You would do transfer on death so that the money is all yours and only yours during life. If the agent under power of attorney needs access to it, they would use the power of attorney. But yeah, you can name beneficiary. And that's, I'd say, the preferred route. But as Kevin talked about earlier, We don't want everything to be TOD or a trust for, because we need money to come into the estate to pay the bill. So if you have a house, we need to be able to pay the inheritance tax, utility bill to keep things afloat. If everything is TOD or in trust for, then we kind of have to ask the heirs to loan the estate money until the house or something sells. And what if you have 3 children and only one's willing to part with the money to give you a loan? Well, that's not fair to that person who may have cashed in some of the portfolio they just inherited to loan the estate money, when the other 2 are just sitting watching their money grow. If you have enough money coming into the estate to pay the inheritance tax and all those bills, that's what we try to reach, a balance. Tax, a lot of it in, in trust for TOD, but we want enough coming into the estate to pay all the bills that we're gonna need. Okay. Yes.
If you have a power of attorney, what is it that makes that document legal? Is it filed somewhere, or is it just signatures?
Love it. Everyone hear the question? Okay, so the question is, well, if you have a power of attorney, what makes it legal? First of all, Pennsylvania has specific requirements. The front page of a power of attorney has to look a certain way and say something. It's a statutory requirement. So if you don't have that, that's not going to be helpful. And then there's a page at the back of the power of attorney that's a statutory requirement that says your agent, whoever your name. So when I name Kevin as my agent, before he can act on my behalf, he has to sign that notice page in the back that says, yes, he accepts the duties and responsibilities as power of attorney, and he's going to abide by the law. So he can't use that power of attorney until he signs it. So you don't need, you don't have to record it anywhere. It's kind of a waste of money. The only time you need to record a power of attorney is if you're selling real estate and you're using the power of attorney. You have to record an original power of attorney to show who's in charge and that they're allowed to sell real estate. You'll get the original back. So, it's just basically making sure it complies with Pennsylvania law, and you sign it in front of 2 witnesses and a notary, it's valid.
So it has to be notarized.
The power of attorney does. A medical directive does not, but medical directive needs 2 witnesses, does not need notarized, but a power of attorney does need 2 witnesses and notarized. And your notary cannot be one of the witnesses.
What is state POAs? Are they legal in?
So the question is, what about out-of-state power of attorneys? Are they legal in Pennsylvania? The states are going to give full faith and credit, among states and documents, unless there's something in, let's say, the power of attorney that's being presented that violates Pennsylvania law, then it won't be. But we always think, if you're coming from another state, you should probably just get a power of attorney, because a lot of times it's the bank tellers who are going to look at it. And if they don't see that Pennsylvania statutory page, they're going to be baffled and not think that it's valid. Not all of the banks send it to legal department first. A couple do. So if you want to make your life easier and for your heir, their agents under power of attorney, just make it compatible with the state so that everybody's used to seeing the same one. Doesn't mean it's not, but they may have to jump through some extra hoops to prove that it's still valid.
I have a trust, except my car is not in the trust. So now what do I do with that?
Okay, so the situation was that you have a trust, but your car's not in the trust. What do you do? That's not the end of the world, because in Pennsylvania, that's the only thing that's not in the trust, let's say, or if you have IRAs, you go look for those in the trust. But let's say the car's the only loose end you have. If you pass away, you don't have to go through probate. There's what's called an MD-39 form. I think you can complete it, and then you can sell it. All the heirs can agree, or you can transfer it to the heir. You don't have to open up an estate. That's like your bypass, your shortcut. And yeah.
So I had a couple of questions. One is, so I'm my mom's POA, both medical and financial, because my brother lived in California for many years. But you were saying when she passes the POA ceases, right?
Okay.
So then she would have to name one of us primary and the other one a successor for.
Well, if the power of attorney is going to cease no matter what when she passes away.
Right, and there's just 2 of us, my brother and myself.
So, so if you're saying you first, and if he's good with money, then he could be the successor.
Okay, or vice versa. Okay.
And sometimes, as long as the children get along, we kind of think co is better, because one, you split up the duties. If one child, who's the one who's usually paying all the bills, gets sick, or their spouse or somebody gets sick, and their plate is too full, You now have the other one to pick up the slack during that time. If you're the only one named and you're having that problem with your family or your health issues, you're still the only agent under power of attorney unless you relinquish control. So oftentimes, as long as it would work and the people get along, a code can be a good thing because if something happens to the one who's acting, you've got somebody who can step in right away. And really, in our power of attorneys, as people get older, like 80 plus or more, we encourage them to name the spouse as well as a child. Because, you know, the older you get, the longer hospital stays are, the more frequent. If you name your spouse as the agent, and now you have cognitive issues, your spouse is in the hospital for 2 weeks, and that's the only one that can access the money, none of your bills are getting paid. But if you name the spouse or a child, that child, when your spouse is in the hospital, can take care of all the bills. And when the spouse comes home and they're healthy, the child, hopefully, that's the idea, will back off and let you take care of your affairs again. And we recommend that when you get older. If you're younger, no, spouses should be the one and only agents for each other.
You mentioned payable on death, transfer on death, beneficiaries, and trust. They all seem to function very similarly. Is there a benefit for?
Well, the trust, well, so the beneficiaries on an IRA, annuity, and life insurance, they're filling out the forms and they're getting the money the way they want it. The trust is usually, you know, it can be set up that the beneficiaries have access right away, but they're usually have strings attached. They're leaving money for grandchildren and they want it for college, or they don't want to blow it right away. They're making sure that they don't have access to it right away. So they all avoid probate, so that part's true. But beneficiaries like the bank accounts, IRAs and annuities, those people are going to get the money back if they want to, like once they fill out the paperwork. The trust, you still have to go through all the same steps as a will. So when somebody dies, whether it's a will or a trust, the beneficiaries have to be notified. You have to put creditors on notice. That's why you see in the newspaper that so-and-so passed away, whether it's a trust or an estate. It's because creditors only have 1 year to come forward from that publication to make a claim. Still have to file inheritance tax. You still have to do an accounting. So all the same steps are there, whether it's a will or a trust. And you don't make any distribution from a will or a trust until all the bills are paid, all the inheritance tax is paid, the Department of Revenue gave tax clearance. Now you can start finalizing the estate. Whereas the IRA, annuity, you can get the money a heck of a lot faster. Well, I know there's still inheritance tax. No way around inheritance tax unless you move across state lines and go to Ohio. Because there's no inheritance tax over there. It's inheritance tax on everything but life insurance. No share, no zero for spouses and zero for charities. Remember, avoiding probate does not equal avoiding inheritance tax.
We have 2 children across state line, one in Ohio, one in Indiana. They still have to pay Pennsylvania inheritance tax, don't they?
Yes. So, you know, if you have a child in Ohio and one in Indiana, the children still have to pay inheritance tax. So if you are the Pennsylvania resident, then yes. It's not based on where the heir lives. It's because you are a Pennsylvania resident. And it's a privilege of dying as a Pennsylvania resident. Any other questions? Right, so then, if we're done, or we can stick around after if you want.
If anyone has any other questions for Kevin or for Carolyn, down for a little bit, some one-on-one. So thank you everyone for coming. Before you leave, if you could fill out your survey that we gave you, we're always looking for ideas for a new Ask an Expert program. So if there's something you would like to hear about in the future, put that within there. I do have some of these estate planning workbooks that Kevin mentioned up in the front of the room too. If you would like to take these with you, just a free resource that we put together at St. Paul. That'll similar to what Kevin has that you can use to gather information. And these are also really nice to share with your children. So they know where this is. so they have an idea of what is happening with your estate. They know what to do. if They need to access any of that information. Any other questions? Yes, there are. You can also find these on St. Paul's website. We have an electronic version on our website that you can click and download and fill those out right on your computer. Would you like to share your contact information? We had a question on Zoom.
So yeah, for the individual on Zoom that asked for my contact information, my office number in Greenville is 724-588-9067. The best email address is info@orsingergroup.com. Thanks.
Any other questions? Margie?
I don't have a question, but I may make a statement. My cousin's husband just passed away and she got a notice after a couple months that the water was going to be turned off. He took care of all the bills and she thought, you know, it was all taken care of through direct from the bank account, but the water was not. And so what you're handing out for us to leave for either a spouse or a child is very important. So thank you for the info to do that.
And it's not unusual. I think in most households, you know, one person handles most of the finances and it's, you know, it's not always the wife, it's not always the husband. It's probably a split of 50-50, but almost across the board. If you have a married couple, one of them knows everything and the other doesn't know where the checkbook is. And that's very common. So yeah, it's to keep each other in the loop is very smart.
And in the book, having something like this, an outline and a roadmap for your agent under power of attorney, your executor. We had a state once where the person did not name the children as, you know, executor, but he had it all laid out. He had the attorney's name and address, the life insurance company's name, address, the insurance agent, the health insurance, the accountant. It was just all laid out for the person to make their job easier, which was a blessing that you're so organized. So that more you can be organized, the easier you're going to make it for whoever's taking care of your affairs during life and after.
Another question.
What is the legal status of, you referred to originally early on, the password protected account? Those accounts that want to put you on, and how do you get access? Even if you have the password, what is your status?
Those are tough to access. So even in our power of attorney, we have language dealing with digital assets, being able to deal with Facebook accounts, email accounts, and things like that. Unfortunately, companies aren't very cooperative. So just make sure you know where your passwords are and you let your family know, because that's probably the only way you're going to get into any of those accounts is with the passwords.
I would think if someone passed away, then you were the executor, would that give you the right or not
They're
necessarily?
really difficult to
Okay.
deal with.
Okay.
Yeah, they should with what's called a short certificate, but those companies are pretty miserable to deal with.
I have a question like on some of your, like bills in that you pay. For example, like my mother had, she got cable, she had it under her name. When she passed away, we went on that account. So we had a hard time getting information about that account, even though my father was still living. His name wasn't on that account. They just would not tell us anything. So do you know in those situations how you get around that? Because we didn't know her name was the only one on it. And I had a hard time getting information. We were trying
Hear
to
the question.
change it. We were trying to cancel it.
Let's say you have a married couple and the utility bills and one of the spouse's name and not both, and then that the person whose name is then passes away, they're having difficulty getting access to information for that account, even though the spouse is still alive. Some companies are just miserable to deal with. Others are going to tell you anything. So hopefully you don't have to get a court order or anything, because that, if it's gonna
When you're
get
doing it.
down to that, basically getting a court order. But you could just try to talk to a supervisor, explain the situation, it's great, house is still jointly, it services both of us, I'm still alive. I need to transfer it over into my name.
Any other questions? Okay, I think I'm gonna have Teresa and Vicki will collect surveys, and we are gonna give away. I just use the board guide before you all head out.
Yeah. Yeah, that's what you gotta do. You gotta start. No. Thank you. Yeah. Parents here, yeah. Not here. It's too much to them, yeah. That ain't. Oh. Right here. That's, sorry.
Have a full, St. Paul.
No. Oh.
We're able to go to get recording that. Well. So I have two that we're gonna play. Like two winners. I know her. The first winner is Gail Major.
The last one.
She cleared that up very well.
Bottom my car.
And Shirley and Chip White.
Aw. She did.
Pull another one, girl? Okay. Lisa, go ahead and pull it up. Whoever this is, you're taking it. Very omen. Now you attend some sporting events at Teal. Your colors there. All right. Thank you so much, everyone, for coming. We're gonna stick around if you have any other questions or you have any questions for us here at St. Paul. We really appreciate your attention.